as to what would happen if you found that there was a Hindu temple, as a matter of fact, under the mosque. Suppose you found there was a Hindu temple. What followed? And the huge structure was probably a temple, said the court, and probably a Hindu temple. Now, this was despite the fact that Buddhist and Jain artifacts were also found. The finding that the court came out with was that there was no Ram temple under the structure. That's a finding of fact. August 1947. Now, anybody who tries to change this, and if there are suits pending at the stage of the act, which is in 1991, those suits will stand dismissed. Very well, unfortunately. If I may just take one case and all its ramifications, just take the Babri Masjid Ram Janam Bhoomi case. Now, incidentally, there isn't just one judgment, the famous judgment that everybody talks about. There are 4 Supreme Court judgments dealing with this. And the Supreme Court, unfortunately, does not speak in the same voice. It speaks in different voices. The entire thing begins with a clarion call first given by the VHP in 1984. This leads to the district judge in 1986 opening up locks where only pujaris were allowed to pray in the inner precincts, and a Shilanyas being done in 1989, which is like a sort of foundation ceremony. This then gets followed and gains impetus by Sri L.K. Advani's great Rath Yatra, if you remember. That Yatra was supposed to be from the temple at Somnath all the way to Ayodhya. Seeing the vociferous tendencies that this would have, the Places of Worship Act was then enacted, to which I'll come a little later, in the next year. But despite that, unfortunately, on 6th December 1992, we all know what happened. And immediately after that, the government of India did 3 or 4 things. First, it appointed a Libaran Commission, which of course slept over it for 17 years and then delivered some report in 2009. Second thing that it did was, it had this Ayodhya Acquisition of Areas Act and concomitantly a presidential reference to the Supreme Court to determine, I would submit rather mischievously, as to whether there was a Hindu temple underneath the mosque. Now, both these came up for adjudication, but before they came for adjudication, in March 1994, a 9-judge bench unequivocally held through various judgments that secularism is part of the basic structure of the constitution, and said that the dismissal of 3 BJP governments in Himachal Pradesh, Madhya Pradesh and Rajasthan by the president under Article 356 were valid because of the riots that broke post the breaking of the masjid. So we had one 9-judge bench judgment speak in ringing tones about secularism and the importance of secularism to our constitution, the breaking of the mosque. And of course, they said that acquisition of an area for a religious purpose be directly in the teeth of secularism, so the whole act must go. Ultimately, of course, what went was only section 4.3, which abated the suits in relation to the Ram Janam Bhoomi thing, because the suits then came back and the presidential reference was left unanswered. The majority saying it's become superfluous, the minority saying that no, it was in fact one-sided. Because we are not told as to what would happen if you found that there was a Hindu temple, as a matter of fact, under the mosque. Suppose you found there was a Hindu temple, what followed in law? And suppose you found the opposite, equally, would the mosque be rebuilt? These were all questions left completely unanswered. So, you had on the one hand, Bomai's case, extolling secularism, and then you had this 3-2 split, where secularism came under a great cloud. Now to come to the other aspects. As soon as the mosque was in fact broken down, there were two FIRs lodged. One was 197 and one was 198. 197 concerned the lakhs of so-called car sevaks who came and actually chiseled the mosques down. And 198 was the senior leaders of the BJP party, LK Advani and company, exhorting these people to do so. Now, on the criminal side, therefore, you had these two FIRs. And until it came to me in 2016, quite by chance, in fact, in 2017, when I was sitting with Justice Pinaki Chandra Ghosh, nothing had taken place with these two FIRs for 25 years. Don't forget, these are FIRs of 1992, which are now being tried in the year of grace 2017. So anyway, 2 years were given. The special judge applied to us again after 2 years. And we said, all right, we'll give you a little more time. What is the progress you have made? So we saw. What was not known to us was that he was due to retire. So once again, 142 came to the rescue. And I think we made an unprecedented order, which is that he will not retire until he goes to judgment. So we caught him by the scruff of his neck and said, no, you will go to judgment. And it took him 3.5 years to go to judgment. And you know what he did? Acquitted everybody. And after acquitting everybody, what happened? He retired and he was made Up Lokayukta in the state of UP. This is the state of affairs in this country. Now, this is so far as the criminal side is concerned. Now, 1885, there was a Mahant Raghubar Das, who was the Mahant of the Ram Janambhumi area in the outside portion. And he filed 2 suits. And he said, I want to construct a temple over only the outside portion, because not only is there a Sita Rasoi there, which was already there, but we have now built a Ram Chabutra as well. And I want to build a temple on this, being owner. Both suits were dismissed. And first appeal dismissed, second appeal also dismissed. What is important to note is that the claim was only qua the outer courtyard, not the inner courtyard. 1934, again you have a riot, in which the 3 domes of the mosque are badly damaged. Reparations are made under some British commissioner, and the mosque is repaired. And then finally in 1949, after independence, in December, there are 50 to 60 people who stormed the mosque and who put idols in there, as a result of which all Muslim prayer ceased. And an important finding is given by the court saying that this doesn't mean that they abandoned the mosque. At no stage did they abandon the mosque. So, it is important therefore to note that each one was praying on either side of the wall for this long period from 1857 at least up till 1949. Of course, an ASI report is gone into in great detail. The ASI in 2003 did a huge amount of digging in the area. And they found a number of artifacts belonging to 9 periods in history. Very interesting. Beginning with Ashoka and pre-Ashoka. So 250 BC and before. And then you got into the Sugha period, Pushyamitra. After the Sugha period, then you came to the famous Kushan period. And from the Kushan period, you went on to the golden age of the Guptas. Now, all this time, you have got only little artifacts. Post-Guptas, you come to the Rajput period, which is a period from the 6th century to the 9th century AD. Here you find something very interesting, because you find a circular shrine. And the circular shrine is said to be probably Shaivite. This is again very interesting, because ultimately in the judgment, nothing is spoken about it being Shaivite. There's a finding earlier. It is called a Hindu shrine later. And after another 3 or 4 centuries, in the Sultanate and post-Sultanate period between the 12th century and the time the mosque was built, you finally had this huge structure under the mosque. And the huge structure was probably a temple, said the court, and probably a Hindu temple. Now, this was despite the fact that Buddhist and Jain artifacts were also found. But one important finding that the court came out with was that there was no Ram temple under the structure. That's a finding of fact, extremely important. So with this finding of fact, they now proceeded to decide the suits. There were 4 of them, 1 on the Muslim side, 3 on the Hindu side, and 1 in the name of the deity, to decide the suits on possessory title, because you have to peg it somewhere in law. Now, the finding that the outer courtyard was used by the Hindus and therefore they had exclusive possession, no problem, all right. When we come to the inner courtyard, that's the mosque itself, there's a big problem. Because here, despite your finding that the Muslims were praying for this huge period from 1857 to 1949, you say, no, we can't say they were in exclusive possession and this site was disputed. Now, it was disputed in the sense that there were egregious attempts to dislodge them, contrary to the rule of law, which is what the finding of the court is. And 3 times this happens. This doesn't happen once. So this happens in 1857, this happens in 1934, this happens again in 1940. And then you go on to say, therefore we can't say that this site is undisputed, whatever that means. And since this site is now undisputed, we can't say therefore that they have exclusive possession of this site. They, the Muslims. And therefore, since this is one composite whole, we now jump to the conclusion that the composite whole now belongs to the Hindus. This is the actual reasoning of the bench. And one other very, very important fact, that throughout this whole exercise, we are also told that every single time it's the Hindu side that has done something contrary to the rule of law. And for that, of course, reparations have to be made. What was the reparation? One would have thought, rebuild the mosque. No. The reparation was, we'll give them some land on which they have to build the mosque. So ultimately, we find that a great, at least in my humble opinion, great travesty of justice was that secularism was not given its due at all by these judgments. And as I told you, they've spoken in different voices. First 2 voices, then the second 2 voices, my voice and the voice of the 5-judge bench. But there is one very important silver lining in all this, and that is the Places of Worship Act. Now, this act was specifically brought, as I told you, and says that it sounds in secularism, which is part of the basic structure, that you cannot look backwards, you have to look forwards. And what does the act say? Very important. Every religious place of worship is frozen to 15th August 1947. Now, anybody who tries to change this, and if there are suits pending at the stage of the act, which is in 1991, those suits will stand dismissed. Abate. If any suit says that the character has been changed, the suit will be disposed of in conformity with this act, which is the same thing, ultimately. And importantly, therefore, we have this frozen position as of 15th August 1947, so that short of Ayodhya, which was kept apart as a special case in those Places of Worship Act, all other places will at least be safe. And we find today, like Hydra heads popping up all over the country, there is suit after suit filed all over the place. Now, not only concerning mosques, but also dargahs. And according to me, the only way of countering this, because all this can lead to, is communal tension and disarmament, contrary to what is envisaged in both our constitution and in the Places of Worship Act. The only way to scotch all this and to cauterize all these hydra heads is by applying these 5 pages in this very judgment and having it read out before each district court and high court, because these 5 pages is a declaration of law by the Supreme Court which binds each of them. And once this is done, it is clear that the Places of Worship Act will take its due course. One other important thing, the minority judge in the High Court, Justice Sharma, had opined that this Places of Worship Act, as a matter of fact, does not operate pre-1991. So that if there's a conversion pre-1991, that won't be hit by the Act. The judgment goes on to say this view is completely wrong and in the teeth of Section 4.2 of that Act. So if this Act were to be applied as stated in this judgment itself, it will easily cauterize all these hydra heads, which are now popping up one after the other every day today. And I may only end by saying that in Justice Chinnappa Reddy's words, unless this is done, what he said will not come true. He said in the great Bijo Emmanuel case, our tradition teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it.